Smoke signals.
Okay, well, good evening. We are now on the record, and this is, as we all know, March 10, 2022. I have to give a little bit of a script here, so please bear with me. My name is Steve DeYoung, and I have the pleasure of being the chair of the Zoning Board of Appeals. We now convene the March 10 meeting of the Yarmouth Zoning Board of Appeals as required by General Law, Chapter 30A, Sections 18 through 25, and pursuant to Chapter 20 of the Acts of 21, an act relative to extending certain COVID-19 measures adopted during the state of emergency. The public are able to attend this meeting either in person or via the alternative public access. Members of the public may watch the meeting live on Channel 18 or watch and or participate in the meeting via Zoom. The meeting notice provides necessary instructions for how to join the meeting via Zoom. And please note that audio, video, and screen sharing functions will be disabled for all attendees. And if you do wish to participate in the hearings tonight, you do need to raise your hand so that our zoning administrator assistant can identify you and put you on the record. We're going to go a little bit out of our order this evening, as we try to do to accommodate people when they have certain needs. And so we're going to start with petition number 4941, that of John Patrick Python and Julia F. Lohman of 8 Thistle Lane, concerning property located at 31 Grist Mill Lane, West Yarmouth, Mass. Property in an R25 zoning district. Tonight, our applicant seeks a special permit under 104.3.2, subparagraph 2 of the zoning bylaws to raise and replace a pre-existing non-conforming single-family dwelling. For those at home, Mr. Singer sits in front, Attorney Singer sits in front of us. Good evening, Mr. Singer.
Good evening, Mr. Chairman. I had submitted a letter to you requesting a continuance to your second meeting in May. The applicants are still before the Board of Health and the Conservation Commission, and so the plans will be tweaking a bit before we come back before you.
Anybody have a motion?
So moved.
Second.
And on that motion, does anybody care to have any? I'm sorry, is there anybody in our audience that would care to speak either in favor or against the motion, the request for continuance? And seeing none, the motion has been made and seconded to approve the request. And we'll take a roll call vote. Mr. Frapery?
Aye.
Mr. Igo?
Aye.
Mr. Martin?
Aye.
And I'm an aye, so sign an extension agreement. We'll see you then.
Thank you very much.
Thank you for coming in.
Was
And that raises,
Was that the May 2nd? No, May 2nd week of May.
Second meeting.
Yeah, the second meeting.
There is an extension agreement in that folder.
oh, okay. Making it tough on me, aren't you? Now I gotta find that folder.
Imagine
49.
losing her. She's gonna get things
4-0.
right in here.
Should be right in front.
You played with the
Here you
folder
go.
first.
Oh, my goodness. Talk about efficient. Look at this. It's already worked out. You must have pull around here or
It's
something.
already got the date on it.
Happy to accommodate you. And so good to see you. But while we have just this topic here in front of us, perhaps the board members, the regular board members, since we're all here, could give me some insight as to how we should respond to somebody that requests the continuance the first time on. They tell us they're not ready by letter or something like that. Is that something I'll feel comfortable? I can just say to the administrator, yeah, sure.
Oh, just
I
let the
think if
administrator.
it hasn't been, I think if it hasn't been heard, I think we should make it up to the discretion of the chair, whether they need to come in or not, depending upon what the subject matter is. I mean, it could be a lot of people that show up and that
Sure,
are anticipating it. So maybe on a case-by-case basis and at the discretion of the chair.
Very good. Well, thank you very much. Good to see you. Now we've got some more insight. All right. And where did we just, let me just take a second here. So where did I just put that extension?
Kidding me? Gets a little here in 30 seconds and we'll be out of here by 6:20.
He's trying.
Stuck in the wrong folder.
He hasn't had dinner yet. So it's-
All right, let's see. We're gonna, council isn't here on the other one.
He's via Zoom.
Oh, he is?
Oh, okay.
Okay, so I know he has another hearing he needs to attend. We're going to then take petition number 4934, that of Elizabeth N. Kaborian, individually and as trustee of the LNK Condominium Trust located at 177 South Street. This particular a matter before us this evening involves property located at 181 South Street, South Yarmouth, Massachusetts. Our applicant seeks to overturn the decision of the building commissioner to revoke building permit number 21-006774. Good evening, council. If you're there, could we allow him in and invite you to say whatever you'd like to say to us this evening?
He is on mute.
Good evening. Thank you very much for giving me the courtesy of taking me out of order. I really appreciate that. As this board is, I just want to make sure you guys can hear me.
Yes, yeah.
Okay, great. Thank you. Doug Troyer on behalf of my client, Ms. Kamborian. This evening, we were before this board back in February, and we had a lengthy discussion about our appeal of the zoning enforcement officer's decision. And it was ultimately reached that we would seek an opinion from town council as to what, get a neutral, in essence, a consultant peer review from town council, identifying what his or her opinion would be on the legal issue at hand. Subsequent to that hearing, I reached out to Mr. Talleyrand's office, and we were advised that in order for town council to make a to do such a request and render such an opinion, that it must be made upon a request by the zoning board of appeal to town council in order to do that, and if necessary, approved by the board of selectmen. I understand that there may be concerns about the fees for paying same. My client is willing to, similar to if this was a special permit for a construction, similar along a peer review, to basically reimburse the town for the expense for town council to do so under section 56G of the statute. So we were asking a request tonight of the hearing so that this board can make a formal request so that we then can get to town council for his opinion.
Okay, I mean, I understand the request. I think oh, yeah, let them just stay on with it. Where did you go? Okay, well, if we could have you join back in.
Oh, I'm actually, I'm still here. Can you hear me?
Okay, good, yeah.
Yeah, it's weird. I couldn't see you guys when I was talking, and it's kind of going in and out, but I am here.
Okay, thank you. So, anybody care to have any discussion on this before proceeding it to a vote? How about you, Mr. Igo?
Yes, I did read the letter from council. I have had a chance to review all of the documents again, as well as the legal argument. And I do understand the testimony that we took last time we were here. I'm prepared to go forward on this matter. I don't think we need to request a legal opinion from town council. I think I understand it. And so I'm prepared to go forward.
I was one that kind of asked for that, I think, more than anybody. So I've read everything twice, and I feel comfortable too moving forward. So I don't feel the need to go in.
How about you, Mr. Martin?
Well, I always like to defer to a petitioner just so that they can have everything they want in front of us, but I think the petition as requested, I guess we've looked at all that, and I think even there's other things involved here other than what the town council, I think, is going to be asked for anyways. So if you guys are comfortable in proceeding, I guess I can be too.
Well, I am only because, again, like Mr. Igo claims to have done, I know I've read everything another time. And I just plain don't think that the petitioner is here, has met its jurisdictional requirements of being here. That is the timeliness of the appeal. So to get to the merits of the appeal, if it had been timely, I might have a whole different point of view on this. But because of its timeliness and quite candidly, I didn't think there was a lot of credibility on the part of the petitioner's testimony. And I don't know what we're going to gain by continuing it, because I know I'm not going to ask a town council to do anything and beyond whatever perhaps somebody in town has done. But in any event, I think we should go forward with a vote too. And does anybody in our audience care to speak in connection with this petition?
I mean, we spoke last time.
Good.
I don't know.
Good, then you don't need to tonight.
No, but we need just, you got the.
Yeah, the,
You have to come to the microphone. Tell us who you are, because the gentleman at home would like to know who you are.
and just to answer, yeah, I think you're probably asking about the plan. The plan was corrected, and I do appreciate that.
That's all.
Could you tell us though who you are? Because-
I'm Dilorda Isaker,
Okay,
181 South Street.
very good.
This matter is very kind of strange. No, but
If you've already said what you had to
yeah,
say,
I mean,
but you were
nothing to
waving
add.
your hand.
exactly.
That's why I invited you up. Does anybody else in our audience, it's okay.
Thank
Does anybody else in our audience care to come up to the microphone, either in favor of the request for continuance or opposed to it, or to have anything to say about this petition? And seeing none, we now close it to public input on the.
Actually, Mr. Chair, are you closing the actual petition, or are you closing the discussion on whether or not to continue? Because I would like to have one opportunity to kind of summarize the legal issue, because I do realize that you guys take a different interpretation, but I would like at least one more opportunity to simply and distinctly identify what we believe is the legal issue surrounding why this appeal has been timely brought, that necessitated what we thought and what this board indicated last time it wanted to have a legal interpretation.
Oh, no, Counsel, I was only closing it to non-petitioner or the public. I was only closing it to the public's input.
Okay,
So,
fair
no,
enough.
We always welcome counsel, and by the way, it's good to see you, and
You as well.
please feel free to tell us whatever you'd like to tell us before we vote.
Okay. Can I do that now? Is now be a good time?
Oh, please, sure.
Okay, so I think we definitely went over a majority of the facts. So I think the one issue that is before the board and what this board is going to vote on tonight is whether or not we timely appealed this building this building permit. I have provided to you the SJC case in Connors versus Anino. That is a 2011 case and is quite honestly the most current and is the highest court in the Commonwealth that has kind of ruled on this issue. And in that case, very similar situation, well, a little different situation. In that case, the parties bringing the appeal actually had conversations with the owners prior to even seeking a building permit. They were aware of when they got the building permit, and they failed to basically appeal within 30 days. In what the court basically held in that case was they interpret section 7, 8, and 15 to mean that when a party with adequate notice of the issuance of a building permit claims to be aggrieved by the permit on the grounds that it violates the zoning code, the party must file an administrative appeal within 30 days of the permit's issuance. Failure to do so deprives the board or other permit granting authority and later the courts of the jurisdiction to hear the appeal. In this case, and also in Connors, the court went further to say that an enforcement request under section 7 and a subsequent appeal from a denial of said request under 8 and 15 remains a valid procedural path for aggrieved parties to follow in appropriate circumstances. For example, an aggrieved request may still be pursued under section 7 if the aggrieved party can establish that he or she was without adequate notice of the order or decision being challenged. As we discussed at the last hearing, the building permit was issued on, I believe, May 25th of 2021. So under this SJC's decision, the 30-day appeal period would have run by June 24th. So the 30 days, if we had adequate knowledge of when of the building permit and if they were proceeding with construction, we had 30 days from May 25th to June 24th to file an appeal. If we can demonstrate, and I believe the facts in this case have shown that we did not become aware until sometime in September. Even the defendants in their submissions to this board have indicated that the earliest that we could have been aware is July 23rd when they started construction by putting the footings into it. July 23rd is well beyond that initial 30-day period. And as a result, the second part is triggered, whereby we have demonstrated that we did not have adequate knowledge of this building permit or the construction of this shed prior to, at the very least, July 23rd, which is beyond that initial 30-day period. Therefore, you look to whether or not we can bring it within 6 years, and there's a defense of latches in which someone could raise. But in this situation, the facts clearly demonstrate that my client did not become aware till September. Upon notice of September and contacting the building department, she filed her initial zoning enforcement request with the ZEO by September 29th, which is well within a reasonable time period for someone to bring such an appeal, given the facts of this case. The decision that I believe this board is maybe misconstruing or just or not 100% agreeing with me on is that there's two appeal periods. The first one is the initial 30 days from the building permit. Facts in this case clearly demonstrate that construction did not even commence until July 23rd by the admission of the defendant. That is beyond the 30 days. At that point, you have to look at the second part of the statute that permits an aggrieved party who does not have adequate notice of it 6 years to basically bring an appeal, so long as there isn't a laches, and you can bring it, but the defendants can bring a laches defense. And in this situation, given the time period, we don't believe that that would have any merit. So respectfully, we would ask this board to find that we have timely brought our appeal. And if in fact this board finds that, then we can go to the merits, or if this board thinks a remand back to the ZEO to make a determination finding that we have actually met that time period and issue a new decision is the appropriate course here. Thank you very much for your time. And I'm hopeful that my explanation and what I believe is a solid reading of the SJC's case and the case law in the Commonwealth, hopefully will persuade you to rule in our favor. Thank you.
Thank you. And counsel, you know, I said it to you at the close of the last meeting. I want to say it to you again publicly here. I think I was abrupt and inappropriate in my tone and tenor in my discussions with you. I'm glad I calmed it down. I'm glad you and I calmed it down. I'm glad we had a chance to speak. On that note, okay, I'm not going to anything else, but
Oh, thank you for that. No, thank you for that.
you deserve that, and so I'm offering it. Okay, does anybody want to, the motion's made, there is no motion. The motion to a request for a continuance is being asked by the petitioner. Does the board care to have any discussion before moving that along to a vote? Because I think we should rule on the request for continuance, and if that's denied, then go forward with the vote on the merits.
I don't know if we have a motion, but I'm going to move to deny the request for continuance.
Does the board care to have any discussion on that before moving it along?
Anybody second that?
I would second it. I mean, I also, just discussion wise, I just feel everything I've read it 2 or 3 times. So I'm comfortable that it doesn't need to go. And as a result of that, I think we should move forward with the petition.
I agree. I think I'm informed from the last time and from my further review of my file, but I'm comfortable going forward and don't need an opinion from town council.
Okay. And how about you, Mr. Martin? You have anything you want to say?
No, I don't think I have anything to add. I understand the reasoning
And I have
behind where we're
nothing.
coming from, and
Sorry.
I don't think bringing it before town council is going to make a change in terms of the overall outcome here.
Thank you. And I'm not going to say anything because I don't think there's anything more to be said. So with that, let's do a roll call vote. Mr. Martin on the motion to deny the request for continuance.
Aye.
Mr. Igo,
Aye.
Mr. Frapery,
Aye.
and DeYoung is an aye as well. So now let's go to what is before us, because as we talked the last time, we can go round and round about whether or not the dimensional requirements have been met or the like. But before we even get to that sort of thing, we've got to have a petition that's properly in front of us. And it's certainly my take, and I said it last time, I'll say it again, after having read these decisions and the correspondence of both counsel for and against the petition. I read them closely. I read the decisions closely, and it's my belief that the petitioner is not truly correctly in front of us because of the lack of filing the appeal in a timely fashion. So there's my mind on it. I don't know if anybody else wants to talk on it. Please feel free.
Well, just so we're clear, the first issue that we have to discuss is whether or not the appeal was timely filed within the 30-day period.
That's
We
right.
don't get to the next question unless we get past that.
That's correct.
If we agree that it was timely filed, then we could address the further issues that the petitioner is raising. So I think the first discussion we need to have is that if we decide it's not timely filed, then we don't even have to go to the other section of the
We
other
can't.
argument. We can't. No,
Yeah.
we can't go further than that. The merits of whether it's dimensionally correct, or whether it's the setbacks are correct, or whether it should be a variance or a special permit or what have you. We don't reach that unless we decide that the appeal was timely filed. Now, in terms of that, if you're looking for my opinion on that, I heard the testimony from the petitioner. I heard the testimony from the owners of the shed across the street. Weighing the testimony, the credibility of the testimony, first off, I find it hard to believe that the petitioner didn't know the shed was going up. I guess they're suggesting that it didn't start the construction until beyond the 30 days. I thought I did hear, if I understand at the last hearing, that there was some discussion between the owners across the street and the petitioner as to what was going to be built. I thought there was an understanding about that. My understanding through the testimony is that took place prior to the 30-day appeal, before June 21st. So if that was the case, then they would have been required to file it within the actual 30-day period. The petitioner testified that she didn't know it was going up. They didn't start construction until July, so it was well past that. She didn't even see it going up until it was actually up. She said she never looked that way when she was coming out of her driveway. I quite frankly know her driveway quite well. I've been going by her driveway the better part of my whole life. I grew up down there on South Shore Drive. I'm very, very familiar with it. I just don't find it credible that she would not have noticed that going up. Whether it started on July or not, the fact that I'm hearing that there was discussions between the parties prior to the 30-day appeal, in my mind, suggests that the petitioner was on notice. Because of those reasons, I don't believe that this petition or the appeal has been timely filed, and I'm going to vote that way, that it was not timely filed. Thank you, Mr. Chairman.
Thank you. Mr. Frapery.
I'm sorry, Mr. Chair, just point of order. With regard to the fact that Mr. Igo just indicated were those communications, those initial communications, may I just identify one thing on those? Because I think it's a misinterpretation of the testimony that was provided last time.
The only thing I would just say is my understanding is this hearing closed right now?
Well, I think at this point, we're asking board members to weigh in on their thoughts before moving it along to a vote. So I don't think we should be debating the facts that Mr. Igo sounds. There's a
No,
record.
and I understand that. It was August, not June. And there was an email that was provided in August. So it's incorrect that there was communications in June. It was actually August. I just wanted that point to be made.
Thank you. So, Mr. Frapery?
I reviewed it like several times, as I mentioned, and from a timeline perspective, it seemed like they had more than adequate time to know what was going on. It just doesn't seem that this is a reasonable request in 30 days. I don't see the credibility of the 6-year situation. I don't think that that comes into play. So from a timeline perspective, I would not support it either.
All right. Mr. Martin, would you like to weigh in?
No, I don't think so. Not at this point.
Silence is the better course. Sometimes.
It's my only virtue sometimes.
I mean, I think I've said enough to, I think I need to belabor my position on it. I think that I don't have a certain memory, but my memory was it was July 23rd. And then to tell me that the appeal isn't taken until sometime in December. Sometime in December is way too vague for me. And I think the vagueness is due to the fact. I think that I think that the reason that there's vagueness is because there's a knowledge on the part of the petitioner that she didn't timely file. And I also think that the case law supports that, that if it's open and notorious and you can see it, that's when you start. Maybe that's when you start the 30 days, but it doesn't fall into the portion of 40A that deals with 6 years for appeal, in my opinion. And so my vote is going to be that the petition is not timely in front of us and should be dismissed.
Mr. Chairman, I'd like to make a motion that we deny the petitioner's request to overturn the November 10th, 2001 determination of the building commissioner.
Second?
Second.
Again, I'd like to do this on a roll call vote, please. Mr. Frapery,
Aye.
Mr. Igo,
Aye.
Mr. Martin,
Aye.
and I am an aye, so that carries on a 4-0 vote that the petition is not properly before us and therefore will be denied. Thank you.
Thank you very much. And thank you very much for taking me out of order. I hope you all have a good evening.
Always try to accommodate.
Thank you, sir.
Okay, so 1940, is that the one we're on now? All right. Okay, hello. All right, so we have before us this evening petition 4940, that of Jack and Audrey Lee of 43 Autumn Drive in South Yarmouth, Massachusetts. That property is in a zoning district, R40. Our applicant seeks a special permit pursuant to 202.5 footnote 5 of the zoning bylaws in the use table to construct a new detached 2-car garage where there are currently 2 existing bays for a total of 4. And would you please identify yourselves for the people at home?
Good evening, Mr. Chairman, members of the board. My name is Eric Tolley, representing Mr. Lee. To my right is his daughter, Erin, and behind us is the general contractor, Mike Ferrulo, in case you should require any information from either of them.
I'm sorry, your first name?
Erin.
Erin, I'm sorry, did I not say that?
No, you said it, I just missed it. That's all.
Erin, I was here last meeting, Mr. Chairman.
Well, why don't you go right ahead and tell us what you'd like to tell us about your petition?
Thank you, Mr. Chairman. As you heard last time, we are seeking relief under 292.5 Q3 footnote 5 for storage of more than 3 vehicles. I think at the last meeting, I was not here, but I watched it, and there was some question as to the consistency between what the application asked for and what the plans indicated. I think the plans indicated that we were asking for a 2-car garage, but what you saw in the elevations was a double door and a single door, indicating that perhaps it could be a 3-car garage. That was not our intent. As I think you heard from Erin at the last meeting, Mr. Lee is retired. He is a car enthusiast and enjoys working on vehicles and restoring them in his free time. So the intent was always to have a two-car garage, and the justification for the double door and the single door was just to allow some flexibility for movement. So after hearing some angst over the discrepancies at the last meeting, we revised the plans to show a single double door with a workshop.
Before you go on,
Yes,
please,
sir.
sir, I just want to point out that at the start of this, you presented to me a photograph,
Yes.
and that is that what you're referring to when you say plans?
No, that
See
is,
a butter.
I haven't gotten there yet, but that is a picture of the, I think also at the last meeting, Mr. Igo, I think it was you that brought up that there weren't any similar types of accessory structures in the neighborhood. This one is directly to the northwest. This is-
No, I'm just trying to identify it for our record,
Yes,
that we're receiving this as an
Okay.
exhibit and it's duly marked as one. I'll now pass it to the members so they can see.
thank you. So we were just trying to demonstrate that there were similar structures in the neighborhood, and this one is a direct abutter. If you're facing the house, this one is to the left.
Okay.
So that is our case. I think that footnote 5 requires a special permit from a zoning board of appeals for storage of more than 3 vehicles. We are asking, given the fact that the existing house has a 2-car garage, and we are proposing a detached 2-car garage, which I hope is clearly identified as such, both by labeling on the floor plans and by the change that we've made to the front elevation, that we are asking for your approval for what would technically be 1 additional car on the property.
Okay. Thank you. And did you have anything you wanted to say?
No, I'm just here in case you had questions.
Okay, thank you. So let's start with you, Mr. Martin. Do you have any question of our petitioner?
I wasn't here for the last hearing, but the building is the same size as before, right? We're just taking a garage door out, really, right?
Sir.
Okay. Yeah, I guess I don't have a big problem. I mean, we're talking about a four-car garage on it's a decent sized lot. It's bigger than many of the lots in that neighborhood. The house next door, I don't know that that's really applicable. Yes, it's a separate structure, and if that was brought up before, then I can see why you might want to do that, but it's only a 2-car garage and there's no garage attached to the house. So I don't know that that's really applicable. This proposed structure meets the setbacks, it's just a question of whether we want to begin, what's the word? I can't remember the word all of a sudden, but when we start to do this, what does that mean for other people? I mean, are we suddenly going to have people coming in wanting a 4-car garage on a small lot? I mean, if this was a big estate, 2-acre lot and so forth, and it was a manor house and a guest house and so forth, then it certainly makes plenty of sense and fits the neighborhood another neighborhood particularly well, I would think. Here, I think it's a little overkill because it doesn't require any setback relief. I think I can probably live with it, but I mean, even the structure hasn't changed size. We lost a door, but I'm sure if somebody wants to, jockey another car in there, they can probably do that. And just because we replaced a garage door with a walk-in door, I'm not sure that makes this a whole lot different, but I guess I'm still a little on the fence right now.
Okay, that's fair. Mr. Frapery.
I don't think I have any questions at this time.
Mr. Igo?
I don't have any questions, but I think my feelings at the last hearing were that the overall structure and the number of garage bays was not in keeping with the neighborhood. I think Dick said it correctly. I think we've been amenable to larger garages with more bays when they're on larger lots. I can certainly think of one over on Thatcher Shore Road. We approved a big house over there, and they came back and they were probably sitting on about 4 acres of land.
Yeah.
Um,
And there was even one we did, I think, on North Dennis Road that was hidden behind the house on an acre lot.
Yeah.
Yeah.
That was a little different. This is a very beautiful structure. I really like it. I just don't think that it's keeping with the neighborhood insofar as it's not a 4-car garage neighborhood.
You are.
I'm
you are
not
correct on that.
against it.
Let him finish and then we'll ask
But
you.
I think in terms of what my feelings were last time, it was, and that's really why this section is in the bylaw here for more than 3 vehicles. You know, I think your door here certainly supports 2 cars in there. I mean, you have a 4-car garage. If you were inclined to close off the other garage doors on your house, you come back and you wanted this in the backyard, that might be different. But you're going to have, I mean, the reason that I'm concerned is if everybody in the neighborhood wants to come in and say, I want 4 garages spaces, I don't know how we say no. You're on a similar size lot. You're in a established subdivision. So that's my concern. Again, it's a beautiful structure, but unfortunately, I feel the same way as I did last time.
Okay.
Precedent was the word I was looking for.
Mr. Chairman, may I add a couple things, please?
Sure, and your client wants to as well, so.
Is he,
No,
Erin is the daughter of the client.
I understood. Yeah. We'll call her the
You wanna- go ahead.
petitioner's rep
Well,
right
I'm
now.
just, yes, I agree with you, Mr. Igo, that yes, there are other dwellings in the neighborhood which only have 1 car. There are some that do have 2.
Mhm.
They do not have the same lot sizes that we do, okay? The positioning of the garage that we're asking for, it will be hidden behind the current house. There's only one other building that could see it, which is that person that they just took a pic that we give you a picture of. The other one, it's in the backyard of their house. You can't see it from the front side of the building, so no one else could visually see it. But the other lot sizes of the neighborhood are not the same size as what we have. So yes, you are correct in the fact that they don't exist in our neighborhood, but they're also the fact that they don't have the space to do what we're asking to do. There was a temporary structure that was permitted prior to us going forward with this request. So there was 1 car housed in that temporary structure. We're asking to do a permanent structure in order to house the restored cars that my father have spent many thousands of dollars on that are award-winning cars. And he's looking to do a more formal structure to house them in.
Thank you. Yes.
Thank you, Mr. Chairman. You know, I don't disagree with the things that Mr. Igo has pointed out, but I think, you know, with each project, it's important to consider setting. This property has no abutter to the rear. There is nobody directly across the street. The house to the left currently has a similar structure. I also think it's important to note that the closest point of this new structure will be 60 feet from the street. And because it's on an angle, the furthest corner will be 80 feet from the street. Erin noted that there was a hoop garage, what they call, and that has been or is going to be removed. And I think is the shed scheduled to leave?
The
So-
shed would also be removed also.
So the shed is slated to be removed in addition to the hoop garage. This is not, you know, it's also set into the sill, into the hill. So it's relatively unimposing. It's only 22 feet high at the front. Not that it matters in the rear because nobody will ever see it, but it's only 16 feet high back there. And as you know, Mr. Martin also brought up, we do check all the boxes from a zoning perspective, with the exception of the fact that we're asking for accommodations for 1 additional car. You know, to the point of, you know, if we do it, then everybody will want to do it. Well, everybody may not have the lot area to be able to do it. So There's just some additional comments and I'll leave it at that.
All right, well, let me weigh in. I'm a little surprised that not only we, but some of the neighbors, is my memory on this one, chimed in just as recently as December. And I thought we had sent a pretty clear message. And yet I'm seeing the same structure, only with wall, the exact same square footage of the garage. And I'm just very struck by that. I'm very sympathetic to you because we have two sports cars, one of which is an antique. We want to keep in the garage and they take up all the garage space. So my everyday cars, we have to leave out in the driveway, because I know I won't get permission for another structure on my property.
Not from
And-
us.
Huh?
Not from us.
And I've got 3 acres and I know it's not going to get in there. So, on a 16,000 square foot lot, I think it's too much. I wish I could say yes and indicate that I feel strongly in favor, of it, but I don't. And so,
Mr. Chairman, could I give a suggestion maybe
Sure.
to the petitioner? In terms of, I believe how they call numbers of cars in garages, it's really like you're doing here. It's a 4-car now. I think you could stay probably within the guidelines of our bylaws that exist. It's a 3-car garage. If you just had one door that, it could even be a little bit bigger than normal door, but not a 2-car door that opens in, and then you can maneuver cars in there potentially. And if it looks like just one door, then I think you might be okay with meeting the 3-car.
Actually need a special permit for 3.
I don't know.
This except for a garage space 4 or storage of more than,
More than 3. Yeah.
but 4.
No, I'm talking about making the 2-car extra door a larger 1-car door.
But I mean,
So
are
they
you
can get in.
suggesting that you can by right have a 3-car garage?
Yeah.
That's not how I read this.
Read it again. I'm sorry.
Except BA for garage space 4 or storage of more than 3 cars.
More than 3 cars.
Well, yeah, but to take out the more, it says, if you take that part out, it says except for garage space 4 or storage, 4 or storage of more than 3 vehicles. I don't know, that's a little, if you
I
took
think
that out,
for-
it should say 4 3 vehicles.
I think for any number of years, we've
No,
allowed 3,
I'll-
we've
I'll
allowed
tell you
3-car
what, I won't
garages.
get into that right now.
Well,
Okay,
may I take that one step further?
sure.
So I read it the way Mr. Martin does. 3 cars is allowed, the 4th or any additional other than 4 requires special permit. My question is this: does that footnote 5 apply to the structure or the property?
property,
It is the property,
sure.
because it's not, the way I look at the zoning table, footnote 5 isn't attached to single-family dwellings. So my question was, could a single-family dwelling have a 4-car garage? But then if you were to add an accessory structure with additional parking, would footnote 5 be specific to the existing structure of the accessory structure?
Well, in this, you're not here because you don't know you need relief, okay? So we know you need relief.
Yes.
And this academic discussion about 3 or 4 cars under footnote 5 is irrelevant as far as I'm concerned, because we're here on this petition that's here, not something that's speculative. I will say to you, we have had petitions that have succeeded in getting 4-car garage space. That was very unique to those. I can think of 2 in all my years on this board. And it was so unique to those 2 properties. You can never accomplish what they did because you just don't have the setup for it. And their lots were considerably larger. And I remember how this board really struggled with it for the very reason that I've just heard Mr. Igo, Mr. Frapier, and Mr. Martin. Well, I'm not sure Mr. Martin, but certainly I'm going to chime in on. It's too much for this neighborhood. I don't care that it's 16,000 square feet. That's not even the zoning there anymore. That's pre-zoning. So I can't support it. I do say to you that I don't have a solution. I don't know that I want to suggest a solution to you. certainly any board member is free to do that, but I don't see any way a 4-car garage storage, 4-car storage will ever pass muster on, for me, on this lot. But you can keep trying, understanding that you can't keep trying if we have a vote on it tonight and deny it. So I don't know.
I think that you expressed some dismay that we didn't address the size at the beginning of the hearing. Is there something, can you give us some guidance? Is there a size that would be more acceptable? I mean, we're at 16.3% lot coverage.
No, if we hadn't had a hearing on December 9 and addressed these same issues resulting in a request to have the petition withdrawn, and something came back that was a fairly substantial change in this, I might have thought favorably about it, but I'm not tonight and I won't. So I am going to, however, invite the public, because there was, is my memory, wasn't there weren't there people that spoke last? Oh, there weren't. Okay.
There was nobody.
All right. Well, in any event, let's see if the public wants to speak tonight. Does anybody in our audience care to speak in favor of this petition? Seeing none. Does anyone in our audience care to speak in opposition to this petition? Come up to the microphone. Seeing none. Does anyone in our video audience care to speak in favor of this petition? If so, please raise your hand so that you can be identified. Seeing none. It's reported that there are none. Does anyone care to speak in opposition to this petition? And again, it's being reported that there are none. So we now close it to public input on the petition. We open it up to board discussions and a vote or deliberation and whatever we're going to do. So,
Mr. Chairman, sorry, Mr. Igo, I think that I can see the writing on the wall. I need a unanimous vote when there's only 4 of you. Is that correct? So I would respectfully request to be allowed to withdraw this without prejudice, please.
So moved.
Second.
and I'm assuming that that request to withdraw is without prejudice. Is that
Correct. Yes, sir.
Okay. The only,
Yes.
that was your motion.
That was my motion, yes.
So does the board care to have any discussion on this motion as presented? All right, let's move it along to a vote then. Mr. Frapery,
Aye.
Mr. Igo,
Aye.
Mr. Martin,
Aye.
and Mr. DeYoung is an aye. Therefore, it carries on a roll call vote 4-0 to approve the withdrawal of this petition without prejudice as requested by the petitioner. Thank you very kindly.
Thank you. Have a good
Good
night.
to see you. That brings us to our last matter, and that is petition 4942. Stephen Hetzel, DBA Lewis Bay Builders, and it's concerning property located at 95 Pine Cove Drive, West Yarmouth. That property is in an R25 zoning district. Our applicant seeks a special permit. Well, this is a first.
First,
There's no alternative relief. A special permit pursuant to zoning bylaw section 104.3.2 to add a second story with no change to foundation size on a pre-existing non-conforming single-family dwelling. Good evening.
good evening.
Identify yourself first, will you?
Steve Hetzel, Lewis Bay Builders, the general contractor for Mr. Hayes, who's in the audience.
You've never been here, have you? Huh?
I've been here once or twice.
Why don't you go right ahead?
Mr. Hayes and his family are looking to increase the size of the second floor to open up the bedrooms and an office space because they have a primary residence up in Southborough, Massachusetts, and in the near future are planning on leaving that residence and making the Cape a full-time residence going forward. So in doing so, they needed more space with the second floor. And we're not changing the foundation size. We're going up, but we're staying within the guidelines of the bylaws for the height and not changing bedrooms. And so just trying to see if we can get a special permit to override the bylaw.
Very good. Mr. Martin, any questions about petition?
Do you have any plan of the existing house?
Say again, please.
Yeah, do you have any plan of the existing structure there?
Do I have a plan of it?
Yeah, I'm just trying to see,
Just what's.
just trying to make sure that the
indicated over there.
first floor hasn't changed.
No.
So
not
it's
at
just the
all.
second floor that we're adding on to.
Correct.
So that room's out to the side there? I don't remember that. I guess it is. Okay.
Yeah, over the garage, there's existing.
But that's,
three-
that
three-
sunroom's there to the left of the garage?
The sunroom, we did that last year.
Okay.
So yeah, that's going to stay as is. The second floor, that's on over the garage.
Did you get approval for the sunroom?
We're reconfiguring and then adding an office space over the new second floor.
You said the sunroom was just added last year?
2021, yeah. Early 2021, I believe so.
Yeah, the decision's
Did we-
dated November 4th.
Oh, we do have a relief.
Yes,
Just-
yeah.
I didn't
I'll
see
be
it.
happy to pass it to you.
Okay. So we allowed the sunroom addition to be 17 feet from the street line, apparently. Is that what that shows? Is that
Yeah.
relief for
Oh, I'm
that?
sorry, you were
Okay.
speaking.
I don't have that in my file. Is the septic tank that close to the structure? This plan shows the septic tank like right on top of the structure,
It shows,
like a foot or so from the house.
I'm sorry, I'm a very
It
bad
looks, it
hearing.
looks to me on this as-built plan
Yes,
that the septic tank is like within a foot of the house, which wouldn't be a normal too kosher.
well, the septic has not changed. We're not changing the footprint of the house to that whatsoever.
Just seems weird to me, I guess. I don't know.
It is close.
All right.
There's no doubt about that.
Okay, so there's relief granted for the sideline setback, front setback from Berwick Road. Before, we're going up with the second story. That's not going to go any further. It's not going to be anything further out of the foundation. And apparently over the section of house that's furthest from both road, from the Berwick Road as well, apparently. Okay, that's all I got.
Mr. Igo.
I have no questions. I actually went out and I visited the property and spoke with Steve, so I have a full understanding. I mean, essentially, they're here because they don't meet the rear setback and they don't meet that front setback there on the side. Other than that, nothing else is changing. They're just going up a little bit.
Mr. Frapery.
Yeah, I don't have any questions either.
You know, I just read the decision and I think we kind of set our piece about what was here in October, which really isn't in any way impacting on
Correct.
this.
Correct.
And I got to tell you, I've never been a fan of the existing house that's here now. I don't like the streetscape on it at
But
all.
the owner's right here.
Oh, that's fine, but he's trying to make it different. And I
Yes.
respect that.
Yeah, it looks much better. Yeah.
I think it's a marvelous idea that he go up, and I think it's a marvelous use, particularly when it's not doing anything to the footprint, and you're staying right within it. And it was such, we all concurred that it was a de minimis impact, deviation from the requirements of 20 feet. It was 19.2. And that was as a result of the construction and the addition of the shingles and the.
A few less hairs on my head right now.
No, that's okay. Mine too. I don't have any to loan you, unfortunately. So, you know, I could have to.
So there's already a deck there anyways. Yeah.
Oh, so I mean, I don't have nothing else to say on it. But does anybody in our audience care to speak in favor of the petition? If so, come to the microphone. Seeing none. Does anybody in our audience care to speak in opposition to the petition? please come to the microphone. Seeing none. Does anybody in our video audience have their hand raised to speak in favor of the petition?
There are no attendees.
Okay.
online.
Do we know what?
No one's online.
I guess I don't have to ask the next question then. Nobody there, they're not going to oppose, are they, huh? All right, then that closes the public discussion on the petition. And I know my fellow board members and our wonderful administrator are anxious to get home. So let's move right to it. Anybody prepared to make a motion?
I'll make a motion that we approve the special permit as requested with no conditions.
I'll second that.
Any discussion needed?
Only that I think it's meets the criteria of the bylaw. And I think it's in keeping with the neighborhood, the surrounding zoning district, and with the chairman's taste in houses.
Yeah, forgetting my personal taste, what I do think is that this does not, we've had this debate about going up. Does that create a greater nonconformity? And I'll stand by my position on that it does not. And so
Do is read the mountain bylaw.
we can always have debate, okay? But I'm going to stick with my position. So I can tell you I'm in favor of it. I think you meet the requirements of the bylaw well. I don't see any question about that. And so if anybody else would like to speak, please feel free. And hearing none, Mr. Frapery,
Aye.
Mr. Igo.
Aye.
Mr. Martin.
Aye.
Mr. DeYoung is an aye. Therefore, it's granted, the request for special permit. And a decision will be drafted. It will be filed with the town clerk's office. 20 days must go by before that is considered a final decision. That's a technical waiting period unless somebody appeals. And the decision once filed and time elapsed, you have to bring it to the registry of deeds and record it, returning proof of recordation back to our board. Okay?
Thank you. I've had a lot of experience.
Well, I gotta say it anyway, Steve. God forbid I not say it.
All
I'll
right.
hear. Good to see you.
Thank you very much.
You're quite welcome.
Have a good night.
All right.
Thank you, Steve.
So we have minutes that we have to approve or,
Move to approve the minutes.
all right, everybody,
Second.
those are the minutes for June 24, 21 and February 10, 22. Any discussion? No need? Good. All those in favor of the motion made to approve the minutes and seconded by Mr. Martin, moved by Mr. Igo, please indicate by saying aye.
Aye.
Aye. It carries unanimously. And we now move to adjourn the meeting, right?
Before we adjourn, I want to recognize our outstanding administrative assistant that we are going to be losing
Thank you.
to the Yarmouth Police Department in the future. She's going to be moving on and be the new administrative assistant to the chief of police.
Thank you
And
very
while
much.
we are very, very
Congratulations.
sad to see you go, we are certainly very excited for the opportunities that lie ahead for you.
Me too.
I thought you had one more meeting
Does
in
have
you.
one more
I
meeting.
do.
Well, I wanted to say that anyway.
Well, let me tell you, I'm not going to be at that meeting. I have to tell you, we've had nothing but wonderful people working as administrators of the zoning board of appeals. We had certainly most recently Sandy, but even before Sandy, we had
Rhonda,
Rhonda, who was just wonderful.
Dawn Marie,
Dawn came in and pinch hit after Sandy
she was phenomenal.
decided to leave us. And now we have you deciding to leave us, and it's sad because
Did we tell you you had to get a
work well
replacement?
with this board.
Trying. I'm
Okay.
working on it.
You work well, and you ought to be very proud of the work you do, because we certainly have enjoyed your company. And the fact that you bring food and goodies in is just another plus. So thank you for all you've done for us, and good luck with your new position, okay?
Thank you.
With that, we move to adjourn, and we so do adjourn.
Yeah, okay, good.
So let's see what I have to take home. I got to take home